Hello, folks. Good morning. I see that we're starting just a couple minutes behind, but thanks for bearing with us. My name is Martin Daly. I'm the Director of Water Quality Programs for CDRPC. Today's local government workshop webinar topic is controversial land uses. And before we get into the subject matter of today's webinar, I do want to go over some housekeeping notes. For those of you that do not know us, CDRPC is a regional planning and resource center that serves Albany, Rensselaer, Saratoga, and Schenectady counties. We foster intergovernmental cooperation, communicating, collaborating, and facilitating on regional initiatives. We work with partners to help them address regional problems. We established this webinar series to help planners sharpen their skills and as a vehicle for Planning Board and Zoning Board of Appeals members to obtain the necessary credit hours. Now, Planning and Zoning Board of Appeals members are required by state statute to obtain 4 hours of training per year, and municipalities have a wide latitude in defining what training is acceptable for credit. After each webinar in the series, each attendee that signed in to attend to this event using their email address will receive an email confirming attendance. And this email may be submitted to your municipality for consideration of credit. If you're calling in, no email will be sent, so please contact CDRPC with the phone number you used to call in, and we can check that number against the attendance record and be able to fashion you with a certificate, an email that confirms your attendance, and you can present that to your municipality. For practicing AICP certified planners, we have submitted this session for 1.5 hours of CM law credits for the APA. A couple of housekeeping notes. Our attendees do join with video and audio off for security purposes. But if you have a question, we really want to encourage you to engage in dialogue with our presenter and be part of this series. It always makes the process, the webinar more engaging and more vibrant. So if you do have a question, either utilize the chat function or the question box, and I'll open your microphone to ask. Just note, I have a question or I would like to ask something, and I can certainly relay that question to our presenter. If you don't feel comfortable asking, that's fine. Just post a full question and I'll read the question off. So you can do it one of two ways if you have a question. I just encourage people to be able to engage in dialogue with our presenter. I think it makes much more lively webinar. We do archive our presentations. If Amy does share any material, we will share that as a PDF, and we do record the presentation as well. That'll be on YouTube. The links to these materials will be on the Eventbrite website, with which you use to register for the series of webinars, and you'll be able to find that link in the email that's sent out after the session. Now let's get into the meat of the program. Municipalities are constantly faced with new and emerging controversial land uses. And determining how to regulate these land uses is one of the most challenging issues for a planning agency to resolve. I speak from experience. I sit on the City of Albany Board of Zoning Appeals, and it's oftentimes a challenge to be able to determine the right path forward for some of these uses that are not defined in code. From rural eyesores to unwelcome city neighbors, this program examines recent case law dealing with these controversial issues, including things like methadone clinics, homeless services, vacation rentals, and protest art installations. We'll learn how to address them illegally while sustaining community character and accommodating the ever-evolving needs of residents, visitors, and businesses. And we are very lucky to be joined today by Amy Lavine. She is an attorney with the City of Albany's Corporation Counsel's Office, but she is also experienced in research and writing, and she has been published in various legal journals, including the Urban Lawyer and the Zoning and Planning Law Report. If folks are familiar with those two materials, they're excellent. So with that, I will turn it over to Amy and welcome her and thank her for joining us this morning.
Hi, so first of all, I do have a PowerPoint. Shall I share my screen?
Sure, that's totally up to you. But it is helpful for folks that are looking to seek archives later on. Here we go.
Now I can't see myself though. So hold on a second. There I am. So thank you for that great introduction. I just want to emphasize again that people really should chime in if they have questions, or if something that I mentioned rings some bells about some other uses that they might want to chat about. Most of what I'm going to talk about is just a lot of case law, and I apologize that the PowerPoint is actually really boring. There's only one picture. It's mostly just a list of case law in case you want to look these things up later. I didn't include links to anything, but if you Google the name of the case, most of them come up pretty quickly. So in addition to working at Corporation Counsel for the City of Albany, I'm a regular contributor to the American Law of Zoning Treatise, which is this massive tome on zoning law. And in particular, what I've been doing for about the last decade or so is I provide case law updates about every 6 months to it. So I tend to see a very broad variety of all sorts of zoning and planning cases that are coming up across the country. And it gives me a chance to, to see what kinds of new and controversial land uses seem to be becoming trends in this area of the law. I have limited all the cases that I picked out to New York State and federal district courts in New York. So those cases. Hopefully some of these will be interesting to all you guys. So this is my one picture. Oh, what's going on? Sorry, guys. This is my one picture, and I'll talk about this case a little bit later. This is in Potsdam, New York, and as you can see, these are toilet planters, I think is what their creator called them, or porcelain planters. This property owner, if I remember the facts of the case correctly, he had somewhere around like 125 or 150 of these installed all along his properties in the city of Potsdam. So this is, of the recent cases that I've looked at, this is one of the more amusing, I have to say. If you'll just bear with me for a moment, I wanted to start out with this kind of thought, and I don't normally quote Donald Rumsfeld, but this is a particularly interesting quote, which he actually, he gave to a reporter in response to a question about whether or not there was any evidence about weapons of mass destruction. And the quote has nothing, I mean, it doesn't really respond to that question at all, but it raises some interesting kind of philosophical ideas. There are known knowns, known unknowns, and unknown unknowns. And I think that when it comes to dealing with controversial land uses, there are certain things that we know about them. There are certain things that we know somewhat, but we can't say for sure until these uses pop up. And then there are also the unknown unknowns, like the porcelain planters, which I think most people probably can't ever expect as land uses until they actually exist in our world. So just with that thought, I will go into more of the meat of all of this. I wanted to start off just with some citations to the Zoning and Planning Enabling Acts in New York State. This is just for reference for all of you. So I have the statutes for cities, towns, and villages here. These are the enabling acts for zoning interpretation, variances, comprehensive planning, site plan review, and special permits. The zoning enabling acts generally, they set forth what municipalities are able to do in terms of regulating land uses. And they provide a lot of authority in New York State to do some interesting things. And certainly municipalities have experimented with them quite a bit. So just in generally thinking about the various types of land use controls that are most common, so definitions and districts are obviously a very key part of any zoning law. So the districts are going to split up the municipality into separate areas, and then the definitions deal with particular uses. And definitions can be fairly general in scope, or they can get very specific in terms of what they're regulating. Both the general and specific have, have their values, but oftentimes these cases involving controversial land uses deal with uses that don't necessarily fall within any existing definition, or where the definitions that do exist don't quite fit it, the way that it's intended. As far as dimensional and aesthetic requirements, when I mention dimensional requirements, I'm referring to both dimensional requirements as to specific parcels of land. So these are things like yard requirements, setbacks from the lot line, those types of things. But there are also other dimensional requirements which apply throughout a district. So these might be things that require spacing between similar uses, which say, you can only have one of these every 1,000 feet or something like that. And then aesthetic requirements, I use that pretty generally to refer to all of the various requirements that can be imposed in terms of, what the site has to look like, what the design has to look like, whether there are particular district regulations like historic requirements or form-based code regulations. Under discretionary review, this is things like variance procedures, special permit procedures, conditional uses, all of these types of reviews which allow the permitting authority to exercise a certain amount of discretion in how they're applying the land use controls so that they can come to grips with whatever controversial land uses might arise that they need to deal with. I have comprehensive planning on here, and you guys as planners certainly will know plenty about this. In New York State, comprehensive plans don't have to be a discrete plan that's separate from the zoning, but having that type of separate comprehensive plan can really, it can help in these discretionary review procedures when you're trying to deal with, a controversial land use, and you can point to the comprehensive plan and say, these are our land use goals and policies, and this is how those policies support, whatever action we're taking. Similarly, if you have a comprehensive plan in place, you can make a better case for saying that this controversial land use is a good candidate for having a moratorium so that you can study this use, figure out what to do with it, and just have a sort of temporary hold until you do that and figure out proper zoning restrictions for it. And then I also have on here police power and licensing regulations. These things aren't specifically zoning or land use, but they're different types of regulations that municipalities often enact to address some of the issues that arise with controversial land uses that aren't strictly land use in nature. So things like hours of operation, certain business regulations, requirements that certain uses have to be registered or licensed by the municipality. A good example of this one that I often give is pawn shops, which are generally subject to a variety of different restrictions involving record keeping of transactions, sharing that information with police departments, also licensing and maintaining adequate controls so that people who pawn stuff have the ability to get it back within a particular time. These things, again, they're not strictly land use, but they apply pretty generally in New York and elsewhere, and they affect the way that these businesses are run.
So in that case, Amy, I think you're talking about these licensing as being able to help people determine the type of use or the type of regulatory controls that are placed on the business, which may be outside of the municipality's ability to regulate, but that may begin to dial in how a use is. Picking from an example, a personal care business versus a doctor's office, or a processing facility versus a medical office.
So licensing and police power restrictions, municipalities do have the power to enact them most of the time. There are a lot of state
But I mean,
laws.
something like a liquor license would be handed out from the state, right? So that would be able to determine whether something's a bar versus not a bar or a restaurant.
Yes, a liquor license is handed out by the state, but you could have a municipality that, well, many municipalities, for instance, have hours of operations for bars and restaurants. So bars have to close at, midnight or 2 or 4. So that's an example of, that type of not really land use restriction, but it generally falls within the same kind of genre of what municipalities are trying to do with these uses in terms of, mitigating their impacts on everybody around them. Does that answer your question?
When it comes to defining uses, sometimes those licenses can help a municipality start to define how that use may compare with an existing use that they have in the books.
That is absolutely true. Although, when the courts look at things like that, it's, just because something is defined under a particular licensing requirement in state law, that won't necessarily translate to the definitions that are included in the municipality's zoning ordinances. Sometimes it can be relevant. Sometimes it is. Sometimes it's not quite as relevant. I can't think of a really ideal example of that, but I imagine that this will come up as we continue on through this. So just moving on before I start getting into all of the various multitude of cases, I wanted to go through some of the limitations on local governments, land use authorities. So first of all, there are constitutional limitations, and I listed off the biggest one in my mind, but there are plenty of others. There's some under the federal constitution that I haven't mentioned, and then there are also state constitution issues that occasionally come up, but these are the big ones. So First Amendment freedom of expression, this is the freedom of speech. Uses that engage in expressive activity are, they have constitutional protection. So this includes things like signs and billboards, also adult uses. I don't believe that it's been decided in New York State particularly, but the courts have started to rule also that tattoo parlors engage in freedom of expression and have First Amendment protections. I listed the First Amendment freedom of religion separately. So this generally applies to houses of worship and other religious uses, but it also often encompasses various accessory uses of these religious uses. So, in terms of like a church that operates a food pantry, or like a used clothing operation as an accessory use, would fall under that. Also, maybe a cemetery. That there are a number of cases in New York that deal with parochial schools, religious schools that are connected to a house of worship. So those may also fall under that. The Second Amendment is an interesting one, and it's a fairly new constitutional issue to come up in zoning cases. This is following, there was a Supreme Court case in 2010, I believe, that held that the Second Amendment applies to municipalities in terms of their restrictions on firearms. And so since that case, there's been just a growth of case law involving shooting ranges and also firearms retailers. So the Second Amendment comes up in land use law now. Fourth Amendment search and seizure doesn't come up too often in land use cases, but it does occasionally. So this would arise in cases where you have like code enforcement that's entering into a property to do inspections or something like that. I also have an Airbnb case that I'll talk about in a little bit that deals with an interesting search and seizure issue. Fifth Amendment takings, this This is often alleged in all land use cases, and it's rarely successful. But generally, this is a property owner saying that the restrictions on the property are so onerous that they amount to, a taking of their property for which they should be compensated. And then under the 14th Amendment, we have procedural due process. So this is about whether or not, the landowner has received enough notice, whether they've gotten a meaningful hearing, whether there are particular procedural requirements in state or municipal law that have to be followed for, under the federal constitution. Substantive due process, on the other hand, goes to whether or not the restrictions have a rational basis. Basically, whether they make sense, whether there's, a good reason for them to exist. And then equal protection deals with, whether or not particular land uses are being treated unfairly in comparison to other uses that are essentially the same. So beyond those constitutional limits, there are also a host of federal and state laws that generally restrict what municipalities can actually do with their zoning and land use laws. The Fair Housing Act and also the New York State Human Rights Law, these restrict municipalities in terms of their ability to regulate certain housing uses. So this applies to affordable housing. In some instances, municipalities can't unfairly discriminate against affordable housing, but it also applies much more broadly to various uses that include most often group home type uses. So these would be group homes, also residential facilities for the treatment of substance abuse disorders, psychiatric issues, all sorts of residential care facilities. A lot of those are also covered under the Americans with Disabilities Act, which requires municipalities to grant reasonable accommodations to persons with disabilities, and also to not discriminate against them. So the ADA includes things like I said, substance use facilities, rehabs, group homes, various types of uses like that. The Religious Land Use and Institutionalized Persons Act is, it's a federal law that basically it prohibits local governments from imposing substantial burdens on religious uses of property. So in a lot of ways, it's similar to the free exercise protections of the First Amendment, but there are some particular aspects of this law that come up occasionally. The Telecommunications Act deals with wireless facilities siting, and generally it imposes a couple of requirements on municipalities, or actually I should say restrictions in terms of how far they can go in regulating wireless facilities. So this includes basically cell phone towers, and as we're now getting them, 5G small cell installations. I also put down the New York State Human Rights Law. This is similar in effect to the Fair Housing Act, but the New York State Human Rights Law encompasses a broader group of different types of discrimination than the federal law. The Environmental Conservation Law covers a variety of things that intersect with land use. I didn't want to get into too much detail here. There's lots of different environmental laws that may come up in terms of permitting and how uses are regulated. So like wetlands are a good example of that. Generally, they have to get various permits from the state, and municipalities may be limited in what they can do. The Public Service Law relates to utilities, and in some cases, it will override local law in terms of the siting of different utilities. And then I just have this miscellaneous category because there are various provisions throughout the New York State laws that restrict municipalities and what they can do in terms of land use and zoning. So there are provisions of the public health law which relate to the citing of hospitals and medical uses. There's a section of the executive law which requires manufactured housing to be treated the same as site-built housing. The New York State Mining, I can't remember the name of it, the Mining Reclamation Act, it's something along those lines, relates to the operation of mining facilities, not necessarily the location, but when you get into, those issues of sort of police power, things that are not quite land use, but deal more with how the use is operated, there can be some overlap there. The social services law has provisions in particular that relate to homeless shelters and also daycare facilities. Then the alcoholic beverage law, which we mentioned already, and also the agricultural and markets law has some restrictions on what local governments can do in terms of agricultural uses. So getting into my very long list of cases, and again, if anyone has questions, feel free to weigh in. I'm not gonna talk about all of these cases necessarily, but I wanted to list, a good selection of recent cases. And occasionally I have some older cases that are particularly relevant. So in this group of cases with signs and billboards, I guess I'll mention first of all, the last case here, which is Robar versus Village of Potsdam. This is the case involving those porcelain planters that I had the pictures of. And while it's not exactly a sign or a billboard, I included it in this slide because it deals with expressive use in particular. So, aside from having very good visuals, it's an interesting case. It actually arose after this property owner, Mr. Robar, he had wanted to open up, I believe, a Dunkin' Donuts on one of his properties, and he applied for a special permit, and the village denied his special permit. And after that, he was fairly unhappy with the village's decision. And I guess you would call this protest art. He began installing these toilet planters on his various properties throughout the village as a way of expressing his unhappiness with the special permit denial. So this went on for a number of years. I think, if I'm remembering correctly, about 15 years. He continued installing these planters on all of his properties. And, the town or the village, I think fairly understandably had some issues with this. And what they ended up doing was they enacted a law dealing with junk. And they decided that the toilet planters were junk and they had to be removed from all of his properties. So Mr. Robar brought a case in federal court asking for an injunction, and he won. The federal court essentially said that, this was artistic expression. It was also communicating a political message, which was, and I'm quoting here from the case, which was to recount the tale of plaintiff's legal dispute with the Potsdam government over his purported right to convert the property to a commercial use, to memorialize plaintiff's defeat, and to protest his purported persecution on philosophical grounds. He also intended to convey non-political artistic messages to communicate, quote, that beauty can be found in the simplest and strangest items, and to express the, quote, fun, bright, and unique character of his hometown and community. So based on, these expressive aspects of his installations, the court found that he was entitled to an injunction prohibiting the village from removing all of these planters from his property. This case, I will say it's still being litigated. After this, it will deal with more issues when it goes back to the federal court. In particular, there are some issues with the definition of junk and whether or not these toilet gardens qualify as junk. The plaintiff claimed that they're not junk because they're not, quote, worn out or discarded material, but rather he had intentionally placed them on the property. So it'll be curious to see how this proceeds in the federal courts. As far as the other cases here, just let me look at my notes, pick out some of the more interesting ones. So Voss versus City of New York was another sign case that really sort of related to this more sort of personal and political expression. And that case involved a plaintiff who was convicted for displaying an illuminated peace sign in the window of her 17th floor condo in violation of a regulation that prohibited illuminated signs above heights of 40 feet. So the court found in that case that the restriction was content neutral because it didn't have anything to do with what the expression of the message was. And it was narrowly tailored to serve a significant government interest, and it left open ample alternative channels for communication. I did try to find a picture of that, but I wasn't able to find a good one. I'll also just mention matter of Ravina Cayman Selkirk Central School District versus Town of Bethlehem. This was a couple of years ago in our area, and this one doesn't have so much to do with particular political or personal expressions, but it does have to do with electronic messaging signs, which have become an issue in many places throughout the state and the country. And so this was a case where the school district had acquired one of these electronic messaging signs. They wanted to put it out in front of the school, and the town had enacted restrictions against this, but the school claimed that they were that they superseded the town regulations as a school district. The court, however, ruled in the town's favor and said that the school did not get special treatment because it was a school district in this case, and it had to comply with the same sign laws that everybody else did. So in group homes, I have a few cases here. I'm not going to talk about any of these in too much detail, but I wanted to list them. And I have to apologize because my blurb for this this webinar mentioned methadone clinics. And when I was going through all my notes, I realized that I don't actually have any methadone cases from New York State. I will say, methadone clinics are certainly an issue that comes up in a lot of areas, and the courts in other states and other federal district courts have found that they generally fall under the FHA and the ADA, and also another federal statute called the Rehabilitation Act. So they have these federal protections in terms of local governments can't discriminate against them unfairly and also have to grant reasonable accommodations. That doesn't mean, however, that local governments can't impose any restrictions on methadone clinics and other similar uses. So, there are regulations which restrict these types of facilities to particular areas, or which are framed so as to address particular secondary effects of these uses, are generally upheld, although there can be a fine line in these cases between regulations that are honestly, made to address these secondary effects versus regulations which are really more of a pretext to exclude these uses from municipalities. I would also mention, in terms of methadone clinics and other types of group homes as well, that there are a variety of state regulations that deal with the licensing of these facilities in terms of, they need to get particular licenses to provide the types of care that they do. And often under the state regulations, there will be opportunities for local governments to, to try and latch on to some of those requirements and use them as a way to further their local interests. So with the case of methadone clinics in New York State, they're regulated by a state agency called OASIS. And OASIS has regulations which require methadone clinics to submit, basically, I think it's called a community plan. And this type of plan basically is supposed to show how the methadone clinic is intending to interact with the neighborhood and to make sure that the facility is not having, disproportionate secondary impacts. From what I've heard anecdotally, this is not always, enforced very well by the state, but this is the type of thing that, local government could bring it into their zoning regulations and say that, that community plan needs to be submitted to the land use authority whenever, the permitting decision is being made, so that there's something on the record that the local government can point to and say, the clinic, decided that they were gonna, provide such and such security measures, that they were gonna install lighting, cameras, etc. So it's a way to kind of work some of those issues into discretionary review without necessarily enacting them into local law. So wireless communications, this is a really long list of cases, I know. And I included a bunch of cases here in particular to demonstrate that the wireless carriers are quite litigious. These cases come up very frequently. The Telecommunications Act is a federal law that basically, it was intended to speed the deployment of wireless technologies throughout the country. And to do that, the federal law essentially says that local governments can't enact zoning or land use regulations which would have the effect of prohibiting wireless communications. And what exactly prohibiting means is something that has been the subject of a lot of litigation. Essentially, though, it gives the telecom companies a lot of leverage in terms of deciding where they want to put their facilities, deciding how they want to build out their networks, how they want to frame issues of coverage gaps and also network capacity. So I don't want to get into a lot of these issues here, but I will mention the Supreme Court case that's listed here in about the middle, City of Arlington versus FCC. That case, essentially the Supreme Court in that case, they affirmed that the FCC has really broad leeway under the Telecommunications Act to enact regulations implementing that. So the FCC has accordingly done so. And the most recent regulation that the FCC has promulgated, that in particular that's relevant to this, was in 2018. They issued a ruling dealing with small cell facilities that it imposed specific time requirements that municipalities have to respond to permit applications for these facilities. And it also put a limit on the fees that local governments can charge for the permitting process, which is fairly low. I believe it's $270 as an annual fee is what can be charged for, for permitting these small cell facilities. So there was a fairly extensive litigation. And the last case here, City of Portland versus United States, was, I think it was a coalition of about 50 municipalities that claimed that these regulations, they went beyond the FCC's authority to, to implement and interpret the Telecommunications Act, in particular with the issue of fees, because, they said that the FCC had come up with these numbers that didn't necessarily reflect municipalities' actual costs in terms of managing the right-of-way and dealing with permitting issues. However, the Ninth Circuit, it ruled in line with the earlier Supreme Court case, and it affirmed that the FCC had the authority to impose these fees and also to impose the time restrictions on permitting for small cell facilities. So if your municipalities haven't already begun to see these small cell wireless facilities be installed, it will be happening soon, I imagine. These are also particularly controversial uses because of a variety of conspiracy theories, which some of them are pretty old, some of them are a lot newer. I imagine that many of you saw some of the news earlier in the spring about people setting these things on fire because they thought that they were spreading the coronavirus. The more sort of traditional complaints about these things is that people believe that they are spreading harmful electromagnetic radiation, which is something that under the Telecommunications Act, local governments are not allowed to consider RF emissions at all when they deal with these things. It's preempted under federal law. So they're interesting things, and you'll be seeing them very soon if you haven't already. Moving on to these animal cases. These are some of my favorite cases. They tend to be, they're enjoyable to read and to deal with, but they do actually deal with fairly controversial land uses in a lot of cases. And this is another sort of area where I would say that a lot of these restrictions, they're somewhat land use, but they also sort of verge into the issue with police power regulations and not so much licensing, but issues in terms of what people are doing, how they're conducting themselves on their property, as opposed to what the property is actually used for. So the first case here, Knoll versus City of Oneonta, it involved feeding cats in a shed. And the court held that it fit into the definition of an accessory use taking place in an accessory structure. Moving down the list, Town of Clifton Park versus Saris. It affirmed the defendant's convictions because he conceded at trial that he kept ducks on his property, even though the property did not meet the 5-acre minimum for harboring poultry. LaRusso versus Nuringer, it upheld the denial of a permit for a backyard coop that was proposed to house about 40 racing pigeons, concluding that such a use did not constitute a customary and incidental accessory use in a residential district. Salton versus Town of Mayfield Zoning Board of Appeals involved a property owner who was operating an illegal home occupation that included keeping and exhibiting exotic animals. And the court found that the animals' cages were not accessory uses and that the property owner did not have any non-conforming use right to continue the keeping and display of these exotic animals. I would mention in reference to that case also that DEC deals with the general regulation of exotic animals in New York State. So this would be another area where there's some overlap with state law. Meyer versus Village of Champlain Zoning Board of Appeals was a chicken case. And the board's decision in that case that keeping chickens on a residential property was an impermissible agricultural use and was not an acceptable accessory use. The court found that that was neither irrational nor unreasonable because poultry husbandry was included in the definition of agriculture in the village code. Blanchfield versus Town of Hoosick was a case that held that a dog training and show dog handling school required a special permit to operate in an agricultural residential district. Both boarding kennels and breeding kennels were permitted uses in that district, but the proposed canine training school did not meet the requirements for either classification, as it was not, quote, a facility that accepts transient dogs and cats for short duration stays, or, quote, a facility where dogs are bred for sale. Wenmalu versus City of Saratoga Springs affirmed the board's decision to grant an area variance for a kennel on a split lot that was zoned residential and tourist related, because the record supported the board in that the kennel would not have undesirable impacts on the neighborhood. And this was principally because the property was surrounded by other commercial establishments as opposed to residences. And it was also relevant in that case that the court agreed that there were no other feasible means to expand the property into a usable footprint. And then the last one here, matter of McFadden versus Town of Westmoreland Zoning Board, is another case about a dog training business. And the court held that it was not a permitted use or an allowable home occupation in a residential zoning district. The court explained in that respect that dog training wasn't, quote, an occupation or profession which is customarily carried on in a dwelling unit or in a building or other structure accessory to a dwelling unit as required under the ordinance. And the court also emphasized that the property owners weren't seeking to carry on their own business, but instead they wanted to lease a portion of their land for use by a third-party dog training business, which further excluded it from being an accessory to the residence. So short-term vacation rentals have been coming up increasingly for the past few years, ever since basically Airbnb became quite as popular as it is now. This is just a sampling. There are quite a few other cases from New York State. There are a lot from New York City, which deals with these, which has particular issues with Airbnb and similar uses. And then there are also a lot of cases that deal with this in terms of homeowners associations and restrictions that aren't necessarily imposed by the municipality, but that involve a similar type of restriction. So the first one here, Atkinson versus Wilt, this was fairly early in terms of these Airbnb uses. And the court in that case held that it was permissible for the owners of a single family home to rent the property as an occasional vacation residence where seasonal cottages were permitted. And it was irrational for the zoning board to classify the property as a, quote, tourist accommodation, which was defined in the zoning code as, quote, a transient facility used to house the general public. A lot of these cases, like this one, deal with a variety of different zoning definitions that relate to transient occupancies. So things like hotels, boarding houses, vacation rentals, seasonal cottages. There's a whole host of different terms that have been applied over the years to describe these sorts of rental uses. And in a lot of cases, local governments are trying to apply old definitions, to this emerging, the platform, internet platforms that deal with these vacation rentals. So, they're trying to apply something like a definition of a boarding house, which in many cases, those definitions, are decades old and were sort of envisioned, in the days when a single family home, you know, the owner would rent out rooms to boarders, and that would be a boarding house. So, you know, it's a very different thing than what Airbnb is doing nowadays. Going
Amy?
on, yep.
Sorry to interrupt you. We do have a question from Justin Cook. So I'm going to open up his microphone. Justin,
Sure.
hopefully you are available. I'm going to open your microphone and jump in, ask Amy a question. You are unmuted. Are you there, Justin? Still be muted. All right. Well, he typed his question in the chat box. So
I'm here now.
go ahead. Go ahead, Justin.
Thank you so much. So I have a question in the Atkinson versus Wilt. Does it specify whether or not the vacation rental is an owner-occupied dwelling or a non-owner occupied dwelling?
I don't remember off the top of my head in that case, but I believe in that case, it was owner occupied and they were renting it out on a seasonal basis, but I could be wrong. A lot of the cases do deal with this issue of owner occupancy though. And if we skip down to the Cooperstown Eagles versus Cooperstown Zoning Board of Appeals. So that case involved, Cooperstown had an owner occupancy requirement for short-term vacation rentals. And the property owner in that case was trying to get a variance from that requirement. Interestingly, they called it an area variance. I'm not entirely sure that I totally agree with that. It's one of those sorts of instances where it's not entirely clear whether the owner occupancy is an area requirement or a use requirement. But the court in that case found that the zoning board properly considered the variance criteria and did not improperly rely on just public opposition to it. So the court found that the zoning board appropriately considered the significance of the owner occupancy requirement under the regulatory scheme for short-term rentals, as well as the lack of any substantial hardship or practical difficulties that would prevent compliance with the law. And although granting the variance might not have resulted in adverse impacts to the character of the neighborhood, the court found that it was a reasonable restriction and within the discretion of the zoning board to deny the variance application. I will say that there are cases in New York State, older cases mostly, that deal with like rent control and those types of restrictions. Rent control is considered to be preempted by state law in most cases, but there are some cases which are more, they don't accept owner occupancy requirements quite as much as this Cooperstown case does. And the reasoning in those cases is that an owner occupancy requirement is really not so much about the actual use of the property as it is about who is using it. And it's one of the fundamentals of zoning law that zoning is intended to regulate the use of property and not users. So there is that line of thought in some of the cases, but most of the short-term rental cases, I would say in New York and throughout the country, they tend to view the owner occupancy requirement as being more related to the actual use of the property, because when you have an owner occupied property and it's being rented out, through Airbnb or another platform, the owner being at the property reduces the amount of negative impacts that those renters often have on the neighborhood. Whereas these rental properties that are intended basically solely to be rented out as vacation rentals, in a lot of municipalities, they've led to situations where they turn into party houses, where the property isn't maintained as well as, other residential property owners in the neighborhood would like, and where there are issues with, all sorts of issues, parking, noise, vacation renters just being generally, irresponsible and not very considerate of the neighbors.
So I have a follow-up question to that,
Sure.
required to like the non-owner occupied, because non-owner occupied transient rentals or vacation rentals, are becoming increasingly problematic in many upstate communities, particularly in the community that I represent, where vacant houses will be purchased. The zoning kind of remains as single-family residential, but then they're put up on Airbnb with occupancy rates up to 10 people. Because it's still zoned single family home, they're exempt from some of the multi-dwelling unit permitting and requirements. So it's almost, and so we're looking at finding ways to regulate that. Is there any case law that is either on this list or related to that that talks and specifically zones in on the restrictions permissible for municipalities on non-owner occupied short-term vacation or transient rental properties?
There are cases about this, and I'm very familiar with this issue. Before I came to the city of Albany, I was a county attorney in Warren County, which is Lake George and portions of the Adirondack, where I believe at one point we counted and there were 400 registered vacation rentals on the various platforms. And a lot of them were being used essentially as non-owner occupied vacation rentals. One of the issues that came up for some of the towns up there in particular had to do with septic and sewage, because in a typical owner occupied single family house, you're not producing the same amount of waste that a rental property that's frequently renting to 8 or a dozen people is going to put onto the infrastructure. So I think certainly there are communities throughout the state that have approached the impacts of these uses with specific restrictions intended to deal with particular impacts. So there might be a restriction on. I'm not sure that I've seen any specific ordinances that limit the number of people that can be rented out to at a particular time, but there are provisions in the building code certainly that deal with the amount of people that you can have in a particular space. Also, there are certainly ordinances which deal with these uses in terms of having noise restrictions, parking restrictions. I'm not sure that any of these cases in particular go into detail with those. There was a case from Lake George, which I believe involved excuse me, like a trailer, like a glamping trailer type thing, a fancy trailer. And that case, excuse me, I don't remember exactly what was going on with it, but it has to do with this issue of connecting to the septic and dealing with that use. And I believe that if I'm remembering it correctly, the court said that it wasn't this wasn't an accessory use that would be permitted in that case. I might be misremembering that one though. Does that answer your question?
Yes, thank you very much.
There's, the Airbnbs have become such a huge issue in so many different places. It's really also very local depending on, the particular environment. So the types of issues that happen in the Adirondacks, where you're looking at these party houses that are being rented out are really different than, the issues that New York City, for instance, experiences with Airbnbs. And in particular, New York City has really been at the forefront in the country, I would say, behind maybe only San Francisco, in terms of trying to rein in these short-term vacation rentals, because they essentially, they take up housing units that could otherwise be rented to long-term tenants, and they drive up the price of rentals, and they drive up the price of housing for basically everybody, and make it more difficult for people who actually live and work there to afford housing. So I was going to mention in particular Airbnb versus City of New York, which is the Southern District of New York case from 2019. This was the City of New York, I mean, among various other restrictions that they have on short-term vacation rentals, they enacted this ordinance which required the platforms to share their data with the city. So essentially, when a person was going onto Airbnb and setting up their apartment to rent it out as a short-term rental, the city was going to then require Airbnb to share that information with the city, so that the city could then make sure that this wasn't that there weren't landlords of multi-unit buildings essentially just renting out every unit as vacation rentals, when that would essentially be a hotel as opposed to a multifamily residence. So this was, the thing about Airbnb is that it's very particular about its data, and it doesn't want to share any of that information. It's been incredibly opaque, dealing with municipalities across the country. And this comes up in the issue of hotel and bed taxes as well. But that case was, it was really interesting because New York City was trying to get a hold of, this issue in terms of affordable housing, and trying to get that information so that it could deal with that more appropriately and find the landlords that were, illegally renting out these vacation rentals. The court in that case, though, said that it was actually a Fourth Amendment violation, that the city was seizing Airbnb's data, essentially. So this is one of those kind of strange cases where the Fourth Amendment search and seizure issues comes up. As far as I know, I haven't seen any other cities in New York try to regulate Airbnbs and vacation rentals in a similar way. I think if I'm remembering correctly, there are a few cities in California that have tried to get a handle on vacation rentals in this way too, that dealing more with the licensing, requiring them to share that data so that the uses can be monitored and dealt with in a more comprehensive way. Just looking through my notes on the other cases here, Fracta versus Town of Hurley. The court in that case held that the owner of a residential property was not required to obtain a special permit before renting his home through an internet site, because the use of the property for those rentals did not fall within the definitions for either a, quote, bed and breakfast or a hotel. The JNPG 10th Avenue case essentially just deals with affirming that New York City could impose violations for these short-term rentals on property owners, even if it was their tenants that were renting out the spaces illegally. Churchill versus Town of Hamburg, which is this was decided just a few weeks ago. The petitioners in that case challenged a determination that they needed a variance to use their house as an Airbnb rental, which the zoning board had classified as a quote tourist home. The court agreed with property owners that zoning board's interpretation lacked a rational basis because the ordinance provided that tourist homes were allowed as a specially permitted use. And as the court explained, if the town board had intended for special uses to be separate from principal uses, it would have separated them into their own category as it did with accessories. The court in that case also found that the zoning board's interpretation was inconsistent with the town law, which defines a special use permit as an authorization of a particular land use, which is permitted in a zoning ordinance or local law. So that one might be a bit more relevant in terms of what you're dealing with up around here as opposed to New York City type issues. Matter of Clinton Rising, I included this one just because it's very recent. It's not very extensive. It basically just upholds a determination that a property was being rented out illegally. And then Worth versus City of Rochester, I don't have that one on there. Never mind. So similar to Airbnbs and these type of platform rentals, I've been seeing more and more often in recent years zoning that's dealing with kind of special events or destination events. When I'm writing my notes on these things, I tend to just call them wedding barns. These are generally large events at large properties, and more often these are rural properties. So upstate farms being used for events as opposed to necessarily having farming going on at a particular moment. And these, as I said, they've been becoming more and more frequent in New York and across the rest of the country. So the first one, Kabrowski versus City of Rochester. The court in this case held that the denial of a permit to host a live music event did not constitute a taking by eliminating the plaintiff's ability to, quote, present seasonal live outdoor amplified music entertainment. The court found that it didn't reduce the value of the property so much that it required compensation under the federal constitution. Lavender versus Zoning Board of Appeals of Town of Bolton. This involved this property in the town of Bolton, the Highlands Castle, which was marketed for weddings and other large gatherings. The court, or the zoning board in that case, found that the use wasn't customary or subordinate to the primary single family residential use of the property. And the court agreed with them on that, finding that it was rational for the zoning board to find that it wasn't a permissible accessory use. The court explained in that case though, and I'm quoting here, it says, "This is not to say that the occasional use of a residential property for a wedding or similar large-scale event would not be permissible as accessory use to a single-family residential use. On an isolated basis, it would be difficult to conclude that the hosting of such an event would not be incidental and subordinate to the permitted residential use of a single-family dwelling. However, the ZBA found that there was something inherently different about petitioner's use of his property that transgressed that expected or customary for a single family dwelling in a residential low density district and justified treating it differently." I think the distinction that the court is trying to get at here is that it is a normal use of a residential property to occasionally have a large event like a party or a backyard wedding type of thing, but it's entirely different when when a property is being marketed for that use and rent it out on, a consistent basis to other people for those types of large-scale events. Clear versus Frost Ridge Campground. The court in that case affirmed the board's determination that live music was a non-conforming use and was permissible on the campground. Brophy versus Town of Olive Zoning Board of Appeals. The court in that case affirmed the zoning board decision allowing weddings as an accessory use to a bed and breakfast. And then Town of Delaware versus Lifer. This was the case by the Court of Appeals last year, and it involved, if I remember correctly, a 3-day music festival out in Delaware. And the zoning regulations in that case, there wasn't anything that specifically regulated 3-day outdoor music festivals or outdoor music festivals in general. But the zoning board in that case had found that it was most closely related to a theater, and theaters were permitted in sort of the more villagey part of the town. And based on that, they decided that, since theaters weren't permitted in the more agricultural areas, that meant that, this type of outdoor festival also couldn't be held on this agricultural property. So the court in that case affirmed the town's decision, and they found that preventing a property owner from holding a music and camping festival did not restrict speech in violation of the First Amendment. And the court also found in that case that the definition of a theater was not impermissibly vague, because it didn't, specifically mention, outdoor music and camping festivals as being part of a theater. So moving on to homeless shelters. I'll start with the three more recent cases. Neighborhood in the 90s matter of West 58th Street, Neibauer versus City of New York, and matter of Sandora versus City of New York. These all deal with New York City issues. And while there are cases dealing with homeless shelters outside of New York City treats homeless shelters a lot differently than the other municipalities in the state. New York City in particular they have this requirement in particular called the fair share requirement. And essentially the city has stated that when it provides homeless services or permits them, it will review whether or not the neighborhood where they're putting it already has a fair share of these uses. So the intent is to not concentrate all of the homeless facilities in one part of the city, and to make sure that the uses are being spread throughout all of the different neighborhoods. So most of these 4 cases involve the fair share issue to a certain extent, and claiming that New York City hasn't fully evaluated whether or not the fair share requirement is being met. A couple of these cases also deal with seeker review. I won't get into too many of the details with these. They're certainly interesting cases though. And I think what I'll mention about them additionally is that New York City has a really very detailed way of defining homeless shelters. There are a variety of different zoning classifications that they can fall under. And they also, it also brings in some of the regulations for homeless shelters under the social services law in terms of how they're regulated by the state. In my experience, a lot of upstate towns don't necessarily have definitions for homeless shelters. There's actually, in the past few weeks, there's been an issue in the city of Gloversville about this, how homeless shelters in particular are defined. And I believe that the City Council in Gloversville is in the process of considering a zoning amendment that would add a definition for homeless shelters and then restrict where they're allowed. The controversy that's been going on involves, I think, a YMCA facility that's being used as a homeless shelter during winter months. And, you know, some people don't want it there. It's been fairly interesting to watch that news develop. I'll mention the City of Albany case here too. So Matter of Sullivan versus Board of Zoning Appeals of the City of Albany. This was a case where the zoning board decided that a church facility that had a parsonage for, I think, about a dozen homeless people, the zoning board decided that that was going to be part of the religious use of the house of worship, the parsonage, and so it could be located in a residential area. And the court, in reviewing that, found that it was a rational and reasonable decision for the Board of Zoning Appeals to reach. So I have cemeteries on here. Cemeteries are a kind of interesting, controversial use. Back, you know, the older zoning cases that deal with cemeteries are, they're some of my favorite, you know, weird land use cases to explain to people, because there are, you know, all these cases from the 40s and 50s that actually go into a fair amount of detail about how cemeteries are undesirable land uses to have in the neighborhood or across the street, because they have a depressing effect on people. They make people think about death. And so, you know, those sorts of explanations aren't generally used anymore. And I think actually, you know, in a lot of instances nowadays, people see cemeteries as not quite as controversial, because they're, you know, they're open space and they tend to be, you know, fairly park-like in their setting. But they still come up in various cases where there's some controversy about them. I believe two of the cases on here, Oakwood Cemetery versus Village Town of Mount Kisco, and also the White Plains Rural Cemetery Association versus City of White Plains. Those two cases involve crematories, and crematories are still seen as a fairly controversial use in a lot of instances. You know, crematories are certainly a distinct use that's, you know, it's different than just a cemetery by itself, but they're also often operated in tandem. In the Oakwood case, a village zoning ordinance that defined a cemetery as not including facilities for cremation, the court there found that that zoning ordinance was not preempted by the state law, which deals with cemeteries, since the state law did not indicate any intent to preempt the field of cemetery zoning, and the laws governing the management of cemeteries did not conflict with the land use ordinance. And then in the White Plains case, a cemetery applied to construct a crematory on its premises. They requested to the board a finding that it was either a permitted use under the cemetery's legal non-conforming use of the property, or that they be granted a use variance to have the crematory there. The zoning board decided that a crematory was not part of the existing non-conforming cemetery use, relying primarily on dictionary definitions of cemetery and crematory to distinguish between the two as distinct uses. And the court upheld that decision. The Roman Catholic Diocese case that I mentioned here, I added this one to the list mostly because this was a case involving the federal Religious Land Use and Institutionalized Persons Act, and this was a case where the court found that a cemetery that was operated in conjunction with Roman Catholic Diocese was considered a religious use and was protected under the federal statute. And then the last one that I have here, Ferncliff Cemetery. This is a case that was decided a few months ago, and it goes into a very lengthy discussion of the history of this particular cemetery and the land transactions that deeded the property back and forth. But aside from that, it dealt with the issue of whether or not the cemetery could add a caretaker's cottage to the property and a garage that would go along with that. The court held that the zoning board had a rational basis for denying the application to build the caretaker's cottage. In particular, because well, I won't go into the details. It had to do with this, this lengthy history of the conveyances of the property, but the issue of caretakers, cottages, and these sorts of cemetery accessory uses, they do come up in the cases fairly frequently in other states, and generally, the decisions like this where a caretaker's cottage is denied, those tend to be upheld. So I have a few energy cases here. Wind facilities tend to be controversial for various reasons, although it seems like a lot of the controversy with them has died out somewhat. Back 5 or 10 years ago, there was a lot more hesitation to them and a lot more objections. In this case, the matter of McGraw, the court found that the trial court erred in granting the adjoining property owners lawsuit to void the town's grant of a special use permit to construct wind turbines up to 599 feet high. The court found instead that the board took a hard look at all of the areas of environmental concern under seeker and made a reasoned elaboration for its decision to permit the wind turbines. One thing that I'll note in particular with wind turbines that I worked on a few years ago was this issue of, when these wind facilities are being installed often in very rural areas, they require, it requires the energy companies to construct roads and construct, basically the staging area so that they can put up these 600 feet tall installations. And in a lot of cases, municipalities have concerns about whether, how those roads will be dealt with once the wind turbines have been installed and the road is not as necessary. And then also, how the municipality is supposed to deal with the decommissioning of these turbines. And so a lot of the more rural municipalities in New York State that have dealt with these things have looked to this land use tool called a post-community benefits agreement, which essentially deals with these decommissioning issues and figures out how they'll be dealt with at the outset of permitting, as opposed to these towns 20 or 30 years later all of a sudden having a non-functioning 600-foot, wind turbine in the middle of, farmland that they can't get rid of. With solar cases, it definitely seems like these sorts of solar farms are becoming more common land uses and more controversial, as opposed to a lot of the solar cases in the past have dealt with like roof-mounted solar on residential. So in Perkins versus Town of Dryden, the court approved the town's approval of a solar project's subdivision plat and common driveway. And in particular, to reach that, it looked to the definition of buildings in the zoning code and found that the solar arrays that were involved were not buildings because they were not, quote, covered or enclosed. Biggs versus Eden Renewables is a very recent case, just a couple weeks ago. It was primarily a seeker case involving this solar farm that was planned for the town of Duanesburg. And the court found that the board's determination to grant the permit for the solar farm, the court upheld it. And they found that it was not arbitrary and capricious, and the town adequately looks at all of the environmental impacts. I put this case matter of Wallach versus Town of Dryden on the list too. This was a fairly significant ruling from the Court of Appeals about fracking, and there was some contention about whether or not local governments had the authority actually to regulate and in particular ban hydrofracking under the zoning enabling laws. The court in this case found that they do have that power. And so that's even with various state laws that deal with gas drilling and other types of extraction statutes like that. Speaking of extraction, I had a few more of these mining cases. Mining cases come up really frequently in New York State. I think I mentioned before, it's the mine land reclamation law that New York State has at the state level. And the statute really, it really regulates how mines are operated, how the business of the mine is conducted, how the extraction is done. And the courts, almost always, they consistently say that state law does not prohibit local governments from regulating the location of those activities. So as long as the local ordinance is dealing with the actual way that materials are being mined from the property, it's generally allowable under New York state law. I mentioned affordable housing before, and affordable housing is certainly probably the most frequently controversial housing use that comes up. I didn't want to get too much into the affordable housing cases though, because that's a whole other discussion on its own. I also wanted to just touch on some of these more niche kinds of housing issues, I guess, that come up. So houseboats, weirdly, are something that's come up from time to time in New York State. I don't remember the details of these cases too well, but they get into this kind of hazy, this hazy regulation of the waters, which, trying to figure out whether or not, the waters that are part of a municipality are subject to the regulation of the municipality or whether they fall under state authority. Generally, though, the New York cases have upheld local restrictions on on houseboats. Mobile homes, I mentioned before, the executive law has provisions that deal with manufactured housing. So manufactured housing includes mobile homes as well as manufactured housing that's made to look more like site-built homes. This case I added here, and essentially there was a property owner that purchased a mobile home park, and after it purchased it, it contended that the village was singling it out and discriminating against it in its application of the drainage regulations. And the court, it's a very preliminary decision from the district court, so this will continue in federal court for some time. But the court found that at this very preliminary stage in the litigation, the property owner made out a viable claim for equal protection because they alleged that the previous owner of the mobile home park and the owner that succeeded it had not been treated the same way by the town and hadn't been made to comply with those drainage restrictions. So there were also a lot of allegations in this case that the town was targeting this property owner in particular, and that the drainage regulations were more of a pretext. Sex offender housing is something that doesn't come up too frequently, but there are restrictions under the state's Sex Offender Registry Act, which deal with where registered offenders can actually live in relation to schools and parks, and I believe some other uses, essentially uses where children are likely to gather. This case in particular, which was decided a few months ago, it involved whether or not those restrictions applied to individuals who were serving periods of post-release supervision after completing their term of imprisonment. And the court found that basically the sex offender housing restrictions applied equally to those people who were on parole or conditionally released. And the court also found that the restriction on housing, I believe it's 1,000 feet from a school or a park or other place where children congregate. The court found that it was a reasonable restriction that was rationally related to the legitimate purpose of protecting children from the risk of recidivism. There's been a decent amount of litigation over these sex offender housing restrictions in other states and in the federal courts. And they're perhaps, I think maybe one of the most controversial land uses, out there, because, nobody really wants sex offenders to have housing options that are located near schools or parks, but there are some, rather serious due process issues that come up when, when people essentially don't have any available housing where they can live because of these restrictions that, basically zone them out of whole communities. I also have this case here about correctional facilities. This case in Herkimer, essentially the court in this case ruled that the county could put its correctional facility in the village, and it was immune from the village's zoning ordinances. So some other sort of miscellaneous cases here. A&P versus town of East Hampton. This was the town in this case enacted basically a big box zoning law, which was intended to restrict large supermarkets and large retail uses, I believe it was somewhere around like 30 or 35,000 square feet. The court upheld it in this case against a challenge that it was essentially excluding those retail uses from the town, and also excluding lower cost options in terms of, big box retailers. The court there basically explained that there was a rational basis for having a size limit on retail uses. And it found that the rule against exclusionary zoning in New York State is intended to apply to housing, affordable housing in particular, and it does not apply to prevent the exclusion of industrial and commercial uses.
Hey, Amy, this is Martin. I wanted to relay a couple of questions, but also put a caveat that we're pushing up against an hour and a half in our time, and you have a lot of material, and I really appreciate the fact that you've assembled all this. The material that you have provided, we will make available to our participants as PDFs, so they will be able to look up these additional cases. If I could, I would like to field the two questions. One, Justin wanted to ask a follow-up question. He's been our #1 caller so far, so I wanted to open his microphone for his follow-up question. I didn't get to it before, and I sent an apology to him, but he had a question about the temporary uses of vacation homes. So Justin, your mic is opened.
All right. So my second follow-up question is there any case law that overturns a municipal government's ability to have a non-owner occupied short-term rental classified as a multi-unit dwelling that would then be subject to essentially the same existing building code and restrictions that are in typical two-family homes?
I would again mention that Cooperstown case, which I believe dealt with in particular 2 and 3 unit buildings in the village. Off the top of my head, I can't think of too many others that deal with like that size of a building, and in terms of defining it as I guess as a single family versus a 2-family. Is that where you're looking at?
Yeah, well, what kind of one of the things that we're finding is developers are coming in and purchasing vacant buildings. They are doing all the work in the rehab, keeping it zoned as a single family house in a single family residential neighborhood that it's zoned for. And then instead of, flipping it and selling it or redeveloping it, they're holding on to it as essentially transient rentals. And it's becoming more and more problematic because, they are becoming party houses. They're advertising, occupancy of this single family home, upwards of 10 people. Some members of our public safety team are, concerned that, they wouldn't allow that many people living in a single family home anyway, according to occupancy standards. So there's this thought of, going through and saying, if, these developers are going to use these for the sole purpose of being non-owner occupied transient rentals, then they should be subject to rental property law, no differently than if it was a single family home that was being rented out to a long-term renter. Because right now they're skirting all those safety checks, the need for emergency exit on second floor, as well as even some of the other additional garbage, for example. So yeah.
So this is actually when I was trying to sort of distinguish the New York City type issues that come up versus upstate in terms of vacation rentals, New York City has probably dealt with these issues more than anywhere else in the state in terms of trying to make sure that multifamily buildings that are being rented out and essentially run as a business, like they're in the business of vacation rentals, that they're being actually, dealt with under more restrictive provisions than buildings that are being, rented out as actual apartments on a long-term basis. And it comes up in a lot of the cases. There's this underlying tension in a lot of the vacation rental cases about whether or not a vacation rental use is actually a residential use or a business use. And the cases in New York and throughout the country, both the zoning cases and the cases that deal with homeowners associations, it tends to be very specific based on the definitions in the ordinance in terms of and the particular use of the property. So, the courts will actually look at the facts of each case, and they'll distinguish between owner-occupied housing where they rent out the property occasionally on Airbnb versus properties that are being bought solely to be operated for a more business use of short-term rentals. However, that being said, even in some of the cases where you clearly have a non-owner occupied property that's been bought as an investment, to rent out as a vacation rental, where it seems like it's a business, there are cases that say, well, but it's still fundamentally a residential use, because when people are using the property, they are, they're sleeping and living there. And, like I said, a lot of it tends to depend on the specific language that's in the zoning law. It tends to hinge on whether or not there are issues dealing with transient residential occupancies as opposed to, lengthier ones. So I don't know that I can give you a great answer necessarily that sums that up. I would be happy to send you some more information about Airbnbs and how they're regulated. If you, Martin, I assume is my email address going to be included somewhere?
Yeah, your email address is included as part of the webinar.
Yeah, so why don't you send me an email, and I can send you, some more information that goes into a bit more detail that perhaps will address some of your more specific questions.
Yeah, and we're just in the beginning phase of this, because right now our village code doesn't actually really begin to tackle any type of short-term rental or transient rental. And it's a relatively new phenomenon for us, as I'm sure it is for others. I mean, we're certainly not a Cooperstown or a Lake George or even a Lake Placid, which I know are dealing with these things. But it is becoming more and more as the capital region does become a travel destination.
I would say though that not having already dealt with these things in your zoning code might actually be a benefit to you. As I said, there are a lot of old-timey kind of residential transient uses that are included in a lot of zoning codes, and they've just been they've been using the same language for 50 or 80 years about boarding houses and rooming houses and things along those lines, which just don't really explain at all what these online vacation rentals are.
Yeah, that actually brings up, it's a good segue to my next question. When you talk about updating zoning code or the ideal zoning code to regulate these uses, are there are there areas that you would recommend for folks to look to for model zoning code or examples of code that people could pull down to be able to begin to craft their own zoning code to regulate or to tighten their zoning when it comes to these uses?
I mean, I think it depends on the particular use. I look, when you talk about like a model zoning regulation, I tend to look to the Growing Smart Legislative Guidebook. But that was published in 2012. And at this point, it's, it doesn't really address Airbnb. As far as Airbnb goes, I'm not sure that I have seen a model regulation because they're the restrictions that have been enacted tend to be so particular based on what's actually happening on the ground in terms of what the vacation rental market is, what the impacts are, what the municipality is trying to control. But that being said, I mean, I'm happy to share with anybody the sections on this that I have in the American Law of Zoning, where, I mean, I've been tracking these cases and being fairly, I would say quite thorough in terms of dealing with them in the treatise since they started popping up probably, 5 years ago with more frequency.
Okay. Well, thank you. We don't have any more questions. We did have one person ask if we're going to have a spring series or a series in 2021. We'll have a spring series that we'll be putting together and making announcements for. So we only have one webinar left in the 2020 series. That one will look at clean energy, solar and waste that communities are incorporating energy storage into their zoning code. So that will be 1 week from today to wrap up this year. Amy, I do want to thank you. We're well over our time, and I want to let people go, but because you have so much information to share. But your presentation, I will share on the website, and people can look up these cases, and it seems very well organized and easy for people to be able to reference. So I'll let you get a closing remark, and then we'll wrap things up.
I didn't intend to get through everything. I wanted to have and more to talk about rather than less. And as far as closing comments, I would just say thank you to everybody for attending and for listening. And again, I'm sorry that I only had one picture. No, there's a lot of ground and a lot of nuance to cover, so it's very comprehensive. I'm sure that there's a full day of material that you could share with us. So I want to thank folks. I'll give another plug for our webinar next week. It'll be your last chance to get credit hours this year. That next webinar will be just 1 hour. That's on solar and energy storage. But I want to thank you. I want to wish everybody a Merry Christmas if you're celebrating Christmas the day after tomorrow, and we will see you next week. Thanks again. Bye-bye, everybody.